Welcome back to the Slop Docket, where we document AI's assault on legal truth, one or two, sometimes more, fabricated citations at a time. I'm your host, an evolving law, information, and technology librarian, ultimately still professionally obligated to care about whether the cases you're citing actually exist. Last episode, we went back to the beginning, Mata versus Avianca and Scott versus Fannie Mae, the loud one and the quiet one. These cases should have been the legal profession's wake-up call. Spoiler alert, they weren't. Today we're fast-forwarding 3 years to the present, June 2026, 3 years after Mata, 3 years after the main ruling, and the legal profession is still drowning in slop. Let's start with the numbers. Since Mata and Scott, more than 1,150 cases in the United States have addressed AI hallucinations in court filings. In federal courts alone, the tally is approaching 750. That's not a trickle, that's not even a flood, that's a tsunami. The quarterly total is on the left, more than 300 from January to March 2026. Nearly another 300 through the end of June 2026. On the right side, there's a grand total of cases in the United States, nearly 1,200 since Mata. And here's the kicker, the pace isn't slowing down. Judges are sanctioning attorneys for fabricated citations at an alarming rate. The misconduct is persistent, the excuses are repetitive, and the consequences, well, they're escalating. So what's going on? Why hasn't the profession learned the lesson? The defenses are falling into categories. First off is the equivalent of the dog ate my homework. That is, I didn't know AI hallucinated. Then, it was only one case. Or, I didn't draft the brief. And of course, there's gaslighting. Increasingly, courts treat these as aggravating, not mitigating factors. Let's break it down. First, the I didn't know AI could hallucinate defense. This one keeps coming up. Attorneys claim they didn't realize AI tools like ChatGPT could fabricate case citations. Courts are not buying it. In a bankruptcy case last year, an attorney argued he'd never used AI for legal research before and assumed it wouldn't just make things up. Judge Slade from the bankruptcy court in the Northern District of Illinois called that position troubling and imposed a $5,500 sanction plus mandatory AI training. The Fifth Circuit went even further, declaring that ignorance of AI risks is no longer an excuse, if it ever was. Here's the thing, by now the dangers of AI hallucinations are common knowledge. Chief Justice Roberts addressed them in his 2023 year-end report on the federal judiciary. Legal ethics CLEs are covering them. The media is reporting on them, and if you're still claiming ignorance in 2026, you're not paying attention. Second, the just one case defense. This one's almost funny. Attorneys try to downplay their misconduct by saying, it was just one fake case, no big deal. Courts are not amused. In Jordan versus Chicago Housing Authority, the attorney at a big-time law firm described a fabricated citation as just an extra, one case out of 50. The court called that characterization unseemly and sanctioned the attorney $10,000 personally with an additional $49,500 against the law firm. The Sixth Circuit in Whiting versus City of Athens rejected the same argument, emphasizing that even one fake case undermines the integrity of the legal system. Because here's the truth, it's not about the quantity, it's about the principle, the rule of law. Third, the delegation defense. This one's a classic, passing the buck. Attorneys claim they didn't draft the offending document, they just signed it. Courts are having none of it. In Perez-Castillo versus Blanche, the Seventh Circuit reminded us that Rule 11 imposes a non-delegable responsibility on the signing attorney. If your name is on the filing, you're responsible for verifying its accuracy, period. Down in the Northern District of Alabama, in Riviera versus Triad Properties, an attorney tried to blame firm leadership and workplace stress for his AI-induced errors. Judge Manasco wasn't buying it. In a severe 105-page opinion, she opposed over $47,000 in sanctions, publicly reprimanded the attorney, and suspended him from practice in the Northern District of Alabama for 3 months. Fourth, the cover-up. This is where things get ugly. Is it a reflection of the times? These are the attorneys who double down on their mistakes, who lie, deflect, or evade responsibility, the gaslighters, and they generally face harsher sanctions. In Rivera, the attorney compounded his initial misconduct by making false statements about keeping clients informed and blaming court staff for filing errors. The court found his behavior tantamount to bad faith and issued severe penalties. And further down in the Southern District of Alabama, in Hemkes versus Fairhope Motor Coach Resort, an attorney's pattern of misconduct across multiple filings led to a $55,000 sanction, a public reprimand, and a recommendation to the Alabama State Bar that he be found incompetent to practice law. Finally, the expanding circle of responsibility. Courts aren't just sanctioning the offending attorneys anymore. They're going after law firms, local counsel, and even considering consequences when opposing counsel fail to flag AI errors. In Nolan versus Land of the Free, a California appellate court declined to award attorney fees to opposing counsel who didn't alert the court to fabricated citations. And in federal court in Oregon, local counsel was sanctioned for failing to review filings prepared by Pro Hoc Vice counsel. That case, Kuvret versus Wisnowski, is one of the largest monetary sanctions awards to date through the end of June 2026, totaling a penalty of $15,500 and nearly $95,000 in attorney fees. The message is clear. Everyone in the courtroom has a role to play in maintaining the integrity of the judicial process. Ultimately, this is systemic failure. The legal profession has not internalized MATA. Warnings have been consistent and highly visible, but it's still happening. Sanctions have increased in severity and frequency, still happens. Same conduct continues across jurisdictions. This reflects a structural, not isolated failure. So why is it still happening? Overconfidence in AI output, economic pressure, time constraints, lack of training or oversight, or is it a complete misunderstanding of AI? Is it simply passing the buck, assuming someone else will check it? It's not just the tech, it's the human. This is not primarily a defect in AI systems. It is a failure of professional responsibility. Verification has always been required. AI did not change that. The duty to confirm authority remains absolute. The problem is reliance without validation. Where does this leave us? 3 years after MATA, the legal profession is still struggling to adapt to generative AI. The rules are clear, the warnings are loud, the sanctions are escalating, and yet the misconduct continues. Why? Maybe it's overconfidence in AI tech, maybe it's economic pressure and time constraints, maybe it's a fundamental misunderstanding of what AI tools can and cannot do. Whatever the reason, the result is the same. A flood of fabricated citations, a waste of judicial resources, and a growing threat to the integrity of the legal system. If you'd like the full analysis with citations, you can scan this QR code. My article, 3 years after MATA. It goes into much more detail. Next episode, we'll take a look at Park versus Kim, a case that shows how courts were getting less patient, how excuses were evolving, and how the profession was finally starting to grapple with the systemic failures that brought us here. Because this isn't a tech problem, it's a professional responsibility problem. I'm your host. This is the Slop Docket, where we take fabricated case citations exactly as seriously as they deserve. Subscribe wherever you get podcasts. Leave a review. If this made you double check your own citations, good. And if you're an attorney thinking, I'd never do that, that's also great. Prove it. Verify your sources every single time. We'll see you next time.